Welcome to A Case for America. I am Austin Hepworth, and I'm here along with Michael Hepworth. My background is as an attorney. Michael's background is as a numbers guy. And we love to talk about America and the amazing country that it is. Today we get to talk about the 11th Amendment. And as we typically do, we like to talk about the balance of liberty and what we think makes America what it is. And so if you're viewing this, you can see the balance here on the screen if you're just listening through a podcaster. Otherwise, we have anarchy on the left, tyranny on the right, liberty at some point balanced in the middle. And to pull us out of anarchy, we believe that laws are necessary. But to keep us from tyranny or a state where laws dictate everything, we have to have morality. And liberty is where law and morality is properly balanced. And we believe that liberty is the state that gives us the most prosperity, the most happiness, and the best conditions for human progress. And so we advocate very much for America to strike to retain this balance. And we definitely argue for the role of morality. And so today with the 11th Amendment, it actually is a really interesting example of this balance playing out. If we look at the text of the 11th Amendment, it states the judicial power of the United States, so this is talking about the federal government, shall not be construed to extend to any suit in law or equity, so basically any lawsuit commenced or prosecuted against one of the United States, and this is talking about states specifically, so one of the United States is a state. So commenced or prosecuted against any one of the United States by citizens of another state or by citizens or subjects of any foreign state. So this amendment is very tailored to a unique issue where a state or an individual sues a state in federal court. So again, you might have to unpack this for a second as you think through it. We have two types of courts in America. We have state courts, where Utah, for example, where I am, has courts that are just Utah courts. They hear Utah disputes. Colorado has its own courts. And then there's federal courts, which are courts held by the US government. And this became an issue pretty quickly in American history, interestingly. And this amendment came about pretty quickly as well, because of a case that arose. There was a case where a man had agreed to do some work or provide some goods for Georgia, and Georgia had agreed to pay him quite a bit of money at the time, over $100,000, and they didn't pay. The man died without getting paid, and so his estate, those that represented his estate, sued to collect from Georgia. They were from South Carolina. So these individuals from South Carolina sued Georgia, the state, in federal court. And Georgia said, hey, look, US government, you don't have jurisdiction to call us into your courts. So no way, we're not hearing this lawsuit. We're not going to be a part of this. And yeah, so essentially telling the estate of this guy, no relief here for you. That was argued, it was litigated up to the Supreme Court basically. And at the time, this was one of probably the Supreme Court's bigger cases. It was actually, the Supreme Court's decision was directly overturned by the 11th Amendment. But the Supreme Court looked at it, and the Constitution, as written, that was passed in 1787, said expressly that the jurisdiction of the federal courts extended to cases of states versus citizens. Now, the states took the position that meant only if they sued a citizen of another state. But the Supreme Court said, no, it's a controversy between a state and citizens of another state, so that can be in federal court. I personally think that was the correct interpretation of the language there. But it produced a lot of fervor among the states. They were quite upset about it because if you're in federal court and you're subject to common law, and common law is where the judges get to make rules, procedures, get to decide certain things, whether you're liable or not. For example, what you can be liable for, if you can be liable for certain personal injuries or not. Then the states would lose some of their sovereignty, they said. And sovereignty to states means that the state is the supreme governor of its own jurisdiction. It gets to decide what happens there. So a sovereign is like a monarch, they're in control. And the monarch would say, if there's a king, they'd say, hey, if you can just sue me for whatever in some other court, I'm not really a king. I don't have jurisdiction over my own land. And that's what the states were saying. They said, look, under the Constitution, we were supposed to be sovereign. We were supposed to be our own kings, essentially be able to dictate our own rules. And if we can get called into court by a citizen from some other state, we don't get to make our own rules. And the states, basically all the states agreed. James Madison agreed. He's considered the father of the Constitution. So he drafted the 11th Amendment, said, yep, oversight in the Constitution, or something we didn't fully think through or spell out. And it was ratified very, very quickly by the necessary number of states and of Congress to become an amendment. So the Constitution, again, America is a fledgling nation. It starts out and starts walking down a path just a few years later. I think this was 5 years after the Constitution's ratified, or first Constitution signed. I think it was fully ratified in 89. And then at 92, we have this case arise. And so they're already at this place where they go, ooh, yeah, big issue, let's amend it. They amend it quickly. The founders are all still involved, basically. George Washington's president, all these different pieces happening. But interestingly, in this case, there was one dissenting judge who said, hey, I don't believe this is proper for state sovereignty, these other things. And that dissenting judge wrote his dissenting opinion on the Supreme Court, and all of America agreed with him, and they amended the Constitution. One other interesting fact is that Georgia was so convinced that the federal courts didn't have jurisdiction over it, it didn't even show up to argue to the Supreme Court. So just a state suing Georgia showed up, made their arguments. The Supreme Court tried to get Georgia to come. They wouldn't show up. So, obviously in the state federal realm, the Supreme Court was still trying to establish credibility. And some of that happened later with the case of Marbury versus Madison, which followed in the early 1800s, where the Supreme Court really gained its credibility, you could say, that made people want to follow it. But Georgia just shrugged it off and said, yeah, what are you going to do about it, Supreme Court? We're not showing up. But this case stands for the proposition of state sovereignty. Now, under the Constitution, if a state sues a state, so if Utah sued Nevada or Utah and Colorado got in a dispute over water, which is an ongoing thing with the Colorado River, those cases would still be heard in federal court, state-to-state type cases. But me as a citizen of Utah, I can't sue Delaware, I can't sue California in a federal court or in any court outside of that state itself. If I want to sue California, I have to go to California, except with cases where they're taking away constitutional rights. Those I may still be able to be in federal court if it's a U.S. constitutional right that applies to the states. But at the time, that largely came from the 14th Amendment. So if you're looking at progression and order in history, you couldn't really take a state to federal court if you were just a citizen because of the 11th Amendment. When the 14th Amendment came along after the Civil War, that opened the door up to a few more lawsuits against states. And so it extended some of that power back. But that took quite a while for the Supreme Court to hold that because it wasn't direct in the 14th Amendment. And so today still, it's interesting, and I don't think that a lot of America understands this, but the governments of each state get to choose whether you can sue them or not. And this is where I think this is an interesting example of the morality balance we're talking about. So the citizens, or the government of a state, so Utah passed a law, and the law is codified in Title 63G, which is general government. Chapter 7 is called the Governmental Immunity Act of Utah. And governmental immunity, or sovereign immunity, means that the government gets to decide when you can sue it and when you can't. Immunity generally means you can't be sued. When you're talking about immunity in the legal sense, it means you can't be sued. We're not talking about immunity in the medical sense. And so the government says in this law, it says, except as otherwise provided in this chapter, each governmental entity and each employee of a governmental entity are immune from suit for any injury that results from the exercise of a governmental function. And so the interesting thing about this is, again, so this is broad. It just starts broad. It says you can't sue us for anything unless we put it in this and expressly allow you to sue us. So I think it's important to stop and talk really quickly about why the states want to dictate when they can or can't be sued. And this is the same as the federal government. They're going to choose when they can or can't be sued. But the policy behind it generally stems from this notion that the government is just a representative of the people. So if you're suing the government, you're suing all the people. And in what situation should you be able to sue all the people in a state? Because you're taking their tax money if you win and you get damages back. And so if you could just sue the government for anything and everything, like you can with every other citizen in America, it feels like, then what happens to government? What happens to taxes? And that's one of the concerns, is to say, oh, wow, we're now liable for this and this and this and this. We didn't do that right. And so there becomes a concern that people won't serve, one, if they can be sued all the time, and two, the tax burden will grow exponentially if people can sue for all the normal things. So it's interesting to look at because we believe in America that these lawsuits help make companies better. We believe they help make products safer. And individual companies have to find a way to stay alive and afloat with these claims that can be filed against them. But the state governments say, no, that doesn't work for us. So, Michael, I'm curious to know your thoughts on that, how you feel about, the notion, one, that lawsuits and liability make companies and products safer and better because they're held accountable for things. And two, it would make it so government couldn't really do everything it needed to do if you could sue it all the time.
Yeah, on the first point, you could probably find good examples both ways. To say that liability forces a company to make a safer product isn't always true. I think we discussed early on about Ford and the Pinto. They were held liable for the car being unsafe in accidents, but they felt that the financial burden was just better to pay off individuals rather than change their product. And there's a number of examples we could go through discussing liability. One interesting one I read about was the FDA required certain labeling to be placed on products that used sesame seeds. Sesame seeds, I don't know a lot about it, but apparently there's a number of individuals with allergies to them, and it seems to be something more widespread. So the FDA felt that it was necessary that labels needed to be placed on anything that either used sesame seeds or was made in a facility where sesame seed products were being used for maybe something else. And many of the producers of food items had many products, and it'd be like one of them had sesame seeds and a bunch of other ones didn't. and they made them all in the same facility. And to reconfigure their machines and print new labels and label everything, they found was going to be really costly. But sesame seeds themselves are really inexpensive. So a lot of these companies just started putting sesame seeds on everything, just so that they didn't have to print these new labels. They just had to print a label that said it had sesame seeds on it. And it was cheaper for them to do that. So I don't know that it's always a one-for-one. You sue, you make something better. I think an example of why this doesn't, what usually makes products safe and effective is generally competition. Generally, individuals having the ability to choose between different items. If a company has to vie for your purchasing power, they're going to try to sell you what you want. If you want something safe, they're going to compete with other ones to try to make their product very safe. A good example maybe of the situation with states and their sovereignty, you could probably look toward, we talk about HOAs a lot, but kind of as a microcosm of this. If you live in a neighborhood that has an HOA and you're in a dispute with your HOA and you end up suing your HOA, what are you really doing? You're suing all of your neighbors. The only money the HOA gets is from its neighbors, or from the people inside of the neighborhood, your neighbors. And so the result of the result of lawsuits dealing with HOAs generally is higher fees. They have to pay legal fees. And so if one neighbor sues an HOA, they're just suing all their neighbors, rates go up. The HOA usually gets embroiled in long lawsuits and they just go on and on. They can never get resolved and rates just continue to go up and up. So one of the reasons that's different than maybe suing a business is it's much harder to have competition when it comes to where you live. Obviously, you can move, but it becomes a very difficult thing if the relationship between you and your HOA gets so out of hand that they're charging high rates. It gets difficult for you to sell your home. People don't want to move into an area where the HOA is embroiled in lawsuits and the rates are really high. And so your power, your sovereign power drops. And I think maybe part of allowing states to legislate, this is when we can be sued and this is when we can't, is part of them trying to maintain some sort of sovereignty. They don't get embroiled in legal battles with their citizens, and then that's all that state is. It's just a legal battle all the time with every citizen angry at the state for something. And they can't leave the state because they can't sell their homes because nobody wants to move to the state. That can be part of the state maintaining its sovereignty to act. And it's, to your point earlier, it's kind of where we rely more on morality. We try to focus on what would be correct principles to follow instead of trying to legislate our way through it.
Yeah, and so thanks for those thoughts. I like the example of the HOA. It's a little bit easier, I think, to understand. If you sue your HOA and you win a big judgment against it, guess what? Your fees go up. And you're going to pay back to pay off your own judgment. Others will as well, but if everyone leaves because the fees are so high now, you're stuck paying for your own judgment. And so there is this interesting conundrum with suing the government and lawsuits against the government, because it comes back when it comes back to the people, and they're representative of the people, and they only get money through taxation, which isn't entirely true. The government does make money off things like motor vehicle registrations and business registrations and licensing radio waves and whatever. But in general, we don't want our government to be a business. We want it just to get money through taxation. And so that's something that, if there is a judgment, taxes have to be assessed somewhere. The money has to be obtained. And the government's not in the business of selling something of value to anybody. So, again, in general, you can probably find some exception to that, like with the radio waves. If you're licensing radio waves, those are of value to people. But the point is more So we sue, there's a problem because now what can we be liable for? How much comes out of the state taxes? Do people even want the job? Because maybe not all the government jobs are the best anyways, and maybe people are doing them out of a sense of duty or public service, but maybe that will stop if we sue them too much. And it's interesting to look at, there's been a lot of lawsuits against police lately. It's changing the landscape for police. Some are still fine. Some say, wow, this is incredibly bad. Don't want to be here anymore. There's too much going on. But it'll be interesting to see if we strike the right balance or not in America, where, again, if you look at a situation where the police were immune from all lawsuits, which the government technically has the ability to do, the government can say all police officers are immune from any lawsuit. What happens is those police officers can become, not all of them, again, there's a lot of great police officers, but some of them can become very prideful, very arrogant, say, well, you can't touch me. No judge is going to do anything. I can do whatever I want. And it can lead to abuses of power. And so states across the nation have legislated to say, even though we can make you immune from a lawsuit, police officer, we're going to open up liability against you in these situations. And that produces an interesting scenario where, again, you look at it and say, now what is it that's producing this, striking this balance? The balance they're trying to strike is based in law and in morality. And it's the moral code of a nation that says, if there's something bad enough that we want to stop, generally the government has opted to let it be sued for those things that it wants to stop. So one of the abuses they've wanted to stop is abuse of police power, and many states have opted for liability associated with that. Another abuse that states opt for, and you can actually see these, I'll share my screen real quick here. So again, if you're viewing, you can see some of these, but this is the waivers of immunity from Utah. You go down a little bit and they talk about sexual battery, sexual abuse in schools by government officials. This is an area where society, morality-wise, feels it's very offensive for these types of things to take place. And so Utah specifically goes through and says you can sue the state, you can sue schools, you can sue cities, whatever, for violations associated with matters of sexuality. And again, from a moral perspective, I think that's appropriate. I think it's necessary to be able to put in place a check or balance, because if these government officials could say, can't do anything, can't sue me, then we know that human nature will lead to some of them abusing that. And so this is an area where the government is attempting to self-regulate some. But again, it's really only going to self-regulate in the areas that society really feels morally pushed to do, or that the government, just to operate, has to allow them to be sued for. So for example, the very first thing that is here says that the government waives immunity as to any contractual obligation. Because if the government needs the garbage guys to go out and provide services for them, or they need to buy office chairs or anything like that, no private party is going to interact with the government if they can't sue to enforce the contract. Why would you sell the government anything? Like this is in the case of the Chisholm versus Georgia case from the very beginning. He provides these services to Georgia. Georgia doesn't pay him. And so what then? If you can't sue the government to get your money back or to get your obligations, if you give them chairs and they don't pay you, no one will do business with the government. So the government from the very beginning knew, yeah, we can make ourselves immune from lawsuit, but in order to function, we're going to have to open up liability in some places. So contracts are there. They go through things. They do make some exceptions to the contract rights. So they say, Division of Water Resources, they're not liable if they sign a contract to deliver water. They're not liable for failed delivery if there wasn't enough water due to drought, other natural condition, or safety condition. And so they're saying, yep, you need to deliver water if you agree to. but if you can't because there's not water, you're not going to be liable for it. They then go through and also talk about other things in this law. But again, it's interesting to look. They're specifically detailing when you can sue them, when you can't. And this 2B here, so section 2B says, is any action brought to foreclose mortgages or liens? So this is saying we need banks to lend to us. If the government's going to borrow money and build something, no one's going to lend us money if they can't foreclose on a government building. And so they know, the government knows, if they want to build a new city hall and they need a bank loan for it because you're going to pay it off in taxes over the next couple of years, the bank needs to be able to foreclose if you don't pay them. So they put some of these exceptions in out of expediency, just what it takes to work to get things going as it should be, to allow the government to operate. But then they also put ones in that are based on morality, that are there to kind of try and help be a check and balance on misconduct by government employees. Another area of misconduct they've specifically opted into is one that lets you sue if a road or a bridge or something's designed with a defect in it. So personal injury style type lawsuits as well. You can sue them for over making a roadway unsafe.
I think one key point to remember here, this isn't saying that states shouldn't open themselves up to legislation. This is saying to us, when we ask for them to open themselves up, I said to legislation, I'm sorry, to liability. When we ask them to open themselves up to liability, we should be careful that we discuss the proposition. Having a state be liable in certain instances is a good thing. But if we make them so liable that they cease to be able to act, then they can't function as a state government. For example, if a police officer needs some sort of latitude in what the actions they're able to take. They're asked to do a very difficult job. And as human beings are imperfect, they're going to need some give and take. If we hold them liable for everything they do, they will just cease to act. They will cease to be police officers. People will stop trying to do it, stop trying to help. And so the onus is on us to find that balance. At what point do we say we need to hold the state liable? And at what point do we need to say we need to back off a little here because the state needs to be able to act? We can't make them so liable that the state now cannot act and cannot be a sovereign entity.
Yeah, and it's a really good point to look at, because I personally am concerned with how much scrutiny there is on the police, that we're kind of the armchair quarterbacks. We're looking at it from a perspective of not being in that situation, not understanding what it's like to be there with someone that might be pulling a gun out on you. And we have all these people talking about de-escalation and all these things. I'm not opposed to training for de-escalation. I'm not opposed to not killing people when we don't need to. But to sit there and have me tell the police what they should or shouldn't do when I've never been in a situation where someone's pulled a gun on me is very hypocritical, I think. And I think there are very many good people that can give very fair feedback and balance on what can be expected of someone and what can't be in those circumstances. But like you say, if they're liable for everything, then, well, we're just going to move on at this point. Now, again, I'm not saying there haven't been some police abuses. There have been some pretty egregious things that happen. That's very clearly, way outside the lines. That's not something we tolerate, and those things happen. But I do get concerned the more we encroach on this area of very difficult calls and very difficult decisions, when we opt to hold people liable or responsible for those things. But also to your point with setting some kind of cap on things as well. Utah, at least, I don't know if every state does this, but Utah does say there's a cap on the amount of money that can be awarded in personal injury type lawsuits or damage type lawsuits, because they're essentially setting a budget saying, we know that we might be liable for this, we're going to tax for it, but it's never going to exceed this certain amount. Otherwise, it could bankrupt the state or force them to incur quite a few extra, tax levies or tax assessments. And so it is this real interesting look at this attempt at a balanced approach. Now, publicly, I don't hear a lot of outcry on either side saying that we're incredibly out of balance with governmental immunity. It seems like this is something that the governments have, for whatever reason, whether it has been force or outcries in the past or groups that have worked on it, or if it's just kind of been government plotting through, they've struck a balance where current media doesn't go off and say, oh, these government's immune from liability, this is horrible, we need to be able to hold them liable. And I imagine there has been some of those things in the past, and that's probably produced some of these other changes to the Government Immunity Act. But again, to me, the Government Immunity Act is an interesting example of the government attempting to self-regulate and the government attempting to strike checks and balances based on a balance between morality and law. The government has the power to say you can't sue us. They've opted to waive that in many situations. And that option to waive it, again, is based on expediency or the morality of society. And so to me, the 11th Amendment is an example of this balance playing out, how American mindset has worked for many years. And we would propose we should continue to try and strike this balance. I don't think it hurts to look at states and see if they're out of balance or in balance. I can share a couple examples of places where I do think there is some imbalance that I've seen. Currently, one in the state of Washington, there was a lawsuit against a social worker and the Division of Child Welfare Services, whatever it's called in Washington, I don't even know. But this was there was a companion case kind of in Utah. So what happened in Utah is a dad had 2 boys. The mom, he was married, the mom disappears. She can't be located. Very suspicious circumstances surrounding her disappearance. But the police can't find enough evidence to pin the dad on a murder. But the mom's never seen again. And she still hasn't been found to this day. And so the dad is under a lot of scrutiny here. The police are looking into him. All of society's kind of against him here, and because most people think he did it. And he leaves to Washington to go be with, I think his parents were in Washington. So he's there, he's got the 2 kids. Washington Child Protective Services are involved because there's been some other issues associated with voyeurism and some things going on with the family he went to. And so they brought the kids out for a supervised visit. And when they did, the social worker's on the doorstep. The dad opens the door, grabs the 2 kids and pulls them inside, and then shuts the door and locks it on the social worker. And then he prior to the social worker arriving for the supervised visit, he had turned on all the gas outlets in the house, from the gas stove, whatever else. And so the house was full of gas. And then he lit a match and blew up the house and killed him and the kids. And so, super sad story. But the family, the grandparents of the children from the mother's side, the mother who's missing, sue the state of Washington and the social worker for negligence, saying that they shouldn't have been there and all these other things. And they win a very large judgment in court. I believe it was $90 to $100 million judgment for supposed lack of supervision or lack of care or lack of doing things responsibly enough. And I look at something like that and I go, I don't know all the details of the case, exactly all of what went on, but if you're a social worker and you're trying to do your job, take some kids out for a supervised visit, and you show up and suddenly someone's violent or rough, locks a door, and then they murder some kids. I have a very hard time saying that you should instantly be liable for that, for negligence. To me, that's broaching on the side of making it so extreme and so many steps have to be taken that it's going to really, really, really make it so people don't want to do the job, one, but also make it very stressful for parents or anyone in that state, because they're going to have to be so much care. They're not going to be able to let you see your kids. You're not going to be able to work with them, trauma to kids, all these kinds of things. There's a ton of balancing to do. And to me, that Washington case is very far out of balance with striking the right approach to saying, hey, government officials need some leeway here. This wasn't a scenario where, there was no proof yet that dad did anything. There was no proof yet he was dangerous to the kids. And obviously, a lot of people want to say the government should just make sure we undo all harm. But there's so many concerns with that, others that we can talk about. We can talk about those concerns in other episodes. But crazy amount of restrictions on your liberty and on your ability to function, to thrive, to be happy, if you can just be classified as a possibility and then they take your kids away from you. Trauma to the kids, all kinds of things happen with that. Another example, though, of things being out of balance, and this is one that has gained some national attention, so I should walk back my statement a little bit earlier where I said that there wasn't a lot associated with this balance. One place that a fair number of groups in America call for a rebalance in is what's called prosecutorial immunity. And currently, to my knowledge, all states do not allow you to sue a prosecutor if that prosecutor comes after you, files criminal charges, and ruins your life, even if they know that those charges were completely false. And the level of prosecutorial immunity has been aggressively upheld by states, by courts, by the Supreme Court, even in super egregious situations. We've got situations where the guy was on death row and the prosecutors had knowledge that he didn't do it, that he wasn't even the person, but they prosecuted him, put him in jail anyways, and never shared the evidence with the defense. The guy sat on death row till about 2 weeks before they found this evidence that had been in the police files for years, been in the prosecutor files for years, and there's still not liability against the prosecutor or the office. They have situations like the Duke lacrosse team, where the Duke lacrosse team, they were national champions. They had a big party, and a lady went to the police and alleged that she had been gang raped by every member of the Duke lacrosse team. And the allegations came out. They were charged with crimes, and they all lost so much, got kicked out. All these different things happened to them. And it turns out it was totally false. These charges were just made up. The lady had just made up the allegations. But in addition to them being false, the prosecutor, it could be shown, knew they were false as well. And that's a point that was very concerning. But he chose to bring the charges still, ruin the lives of so many people, and can't be sued because of these immunity laws. And so there are situations where the government comes out with a very heavy hand. They file criminal charges. They're very expensive for people to defend. You can lose jobs, you can lose livelihood, you can lose friends, family, reputation, and you can be found innocent in the end. And you can't sue for malicious prosecution. To me, it's a problem that there needs to be some balance too. There needs to be some level of morality associated with that. So that's one area for sure. And then the other area would be, we talked about in the state of Washington, potentially putting too much liability and responsibility on a government worker to sort through all the contingencies, to know everything, predict everything, to be able to fully protect people and keep them safe. I don't believe that anyone can do that. The only way to do that is to lock people up and don't let them associate with anybody. And that's not healthy for us, as we saw during COVID. Even the Surgeon General of the US is now telling us how bad loneliness is for our health. And if we interact with people, there's inherent risk to that. But those are things that we have to be willing to tolerate, I think. Michael, do you have any final thoughts or comments for us with the 11th Amendment or sovereign immunity?
Yeah, just to reiterate that while on the face of it, it seems like it's giving the states way too much power, them having that sovereign immunity actually is a protection to the citizens, and it's just a matter of drawing the correct balance. In that the other citizens of your state can't do your state into bankruptcy if we're protected correctly, so that the state can still remain sovereign and make its own choices. But if we can make the balance to where they should be liable in areas that make sense, make moral sense, then we should pursue those. And I think it's a good discussion about. We look at America and we tend to think about federal government. Most everything people like to talk about is at the federal level. The federal government has grown quite a bit, and we love to debate and discuss what happens at the federal level. But we forget that the Constitution, in its framing, created the states, and a lot of what makes America great happens at the state level. And so when we talk about this state sovereignty issue, it's a huge part of what makes America great. And so we should have these proper discussions and figure out what the balance of liberty is, both at the federal level and at the state level. And that's a big part of the discussion.
Yeah, and that's a great point to end on there, that this 11th Amendment really helps solidify the state's sovereignty. And that is something that sets America apart from most every other country in the world. Europe and Canada don't have anywhere near as strong a system of states with anywhere near as many rights or sovereignty. And so America really is this system where there are sovereigns competing with each other, working. And to your point, most of the engine behind America is the states. And so we can't underscore the importance of the states, the importance even of this amendment, and helping to say, no, we're really giving a serious nod to true state sovereignty. And even the federal government is restricted in what it can do because it can't enforce everything against the states. It can't take them into federal court for everything and anything. And so this amendment has given states this place to say, we are sovereign, we're in charge. And that's then given individuals and the government officials the ability to say, okay, but from a moral perspective, how should this power be exercised? And again, we see it being exercised fairly morally, where there's not large outcries on most things associated with government and these types of things. And so there are obviously adjustments. We always need to be working to strike this balance. But to me, it's a very good example of morality in work to say that no, morality really has a place in America. The states have been very serious about approaching that, looking at that. And these governmental immunity acts continue to be updated, and there are things that get added to them that weren't added before as it becomes an issue. And so as a society, if there's things we care about, we want our government to not do, one of the ways that we can have a check and balance is to advocate for the ability to hold the government liable up to certain amounts, because that then helps persuade officials, motivate officials and departments to focus on those issues and not do those types of things. So it's a very unique American system, but it's one that has served America very well for quite some time. And it's one that I think if we continue to work to protect and balance, will continue to serve America well. So thanks for being with us this week. We will follow up next week with the 12th Amendment and go through more of that there. And we look forward to being with you then.